It's a little bit of a different perspective. Thank you, Mr. Chairman, for the opportunity. Good morning, and I really appreciate the opportunity for these hearings in general. You hit the nail on the head. As someone who's focused on gun violence for quite a number of years, I have been frustrated with sort of that dynamic that seems to occur when you get painted into one corner of the room or the other corner of the room the minute you bring up the subject. And I really appreciate the opportunity to present what I believe to be a very reasonable and balanced and meaningful approach to this situation. Following the most recent mass shooting, I'd said that all options should be on the table, and these hearings really do exactly that. They let all options be on the table for consideration. Just by way of quick background, I won't belabor the point. I think many of my colleagues on the committee are aware of my background, but I've been working on gun violence since 2004, first as a prosecutor in the U.S. Attorney's Office and the Montgomery County DA's office. When I came to the legislature in 2010, I continued working on those policies. I've introduced over a dozen gun bills to address gun violence while respecting the Second Amendment, which is obviously a part of our Constitution. As a committee, we've accomplished some good things on that front. We increased penalties for straw purchasers who illegally give guns to those who are precluded from having them. We've increased penalties for those who illegally possess guns and ensured that those who cannot legally possess a gun in Pennsylvania due to mental health reasons are included in the National Background Check Database. That last change alone ensured that 700,000 people with serious mental health issues cannot buy guns anywhere in the country. We've certainly moved the needle, although I think we can move the needle even farther with the proposal that I'm bringing forth today. In trying to address the issue of gun violence, I think we have to take an evidence-based approach and follow the data. According to the Pennsylvania Department of Health, 1,509 Pennsylvanians died as a result of gunshot wounds in 2016. Of those, 929, or roughly 60%, committed suicide with a firearm. This percentage has remained consistent for at least the past 5 years and mirrors the national percentage of suicide by firearm rates, according to the CDC. If we want to make a meaningful difference in reducing gun violence, we must consider not only the tragedy of mass shootings, but an approach that would help address suicides as well. As you may know from news accounts, many mass shootings end in a suicide, either with the individual taking their own life or what's commonly referred to as suicide by cop, where they invite the police to end their life for them. What I think is especially compelling is that the studies show that most of those committing suicides and mass shootings are obtaining their guns legally. And I think that's an important fact that we need to consider as we look at some of the different approaches that are out there. Since the tragic shooting in Parkland, Florida, I've been working on a new proposal that is already in place in 5 states and is now being considered in 31 states across the country, as well as the U.S. House and U.S. Senate. My bill, House Bill 2227, creates extreme risk protective orders in Pennsylvania. Under my proposal, a family member or law enforcement official could ask a judge to temporarily remove someone's guns if they are found to be a danger to themselves or others. Like a protection from abuse order, a preliminary order could be granted immediately if there was sufficient evidence of danger, but would be followed by a full hearing on the matter within days. At this hearing, the subject of the petition would be granted full due process rights, including the right to be represented by counsel and to have one appointed for them if they could not afford one, the right to present witnesses and offer evidence, and the right to cross-examine any witnesses offered against them. Following the hearing, if the judge found clear and convincing evidence that the individual was a danger to themselves or others, the judge would issue an order for them to relinquish their guns for up to 1 year. The bill also makes it clear that the crime of false swearing and false reports to law enforcement apply to anyone who lies in an attempt to obtain an extreme risk protection order. This concept started in Connecticut in 1999, when a disgruntled employee arrived at the lottery headquarters and killed 4 supervisors before killing himself. Prior to the shooting, employees and family members noted how the man was under duress and could snap at any time, and a family member and police were aware of threats of suicide. Then Indiana adopted a version in 2003 after an Indianapolis police officer, Jake Laird, was killed by a man the police knew was dangerous. The police had previously hospitalized him and taken his guns, but were forced to return those guns to him. Before killing Officer Laird, the man killed his own mother and took to the streets of Indianapolis, shooting along the way. He was justifiably killed by police. Next to adopt extreme risk protective orders was California, following the mass shooting, killing 6 people and then a suicide on the streets of Isla Vista. The murderer's family had attempted to commit him, but unfortunately he did not meet the criteria. Prior to the shooting, someone online commented on a video that the man posted of himself, saying that he, quote, looked like a serial killer. In Washington state, the voters adopted extreme risk protective orders with nearly 70% of the vote. A mother involved in pushing the initiative had a son with mental health issues who she described as depressed and increasingly violent. But he nonetheless was able to purchase the gun that he used to kill his stepsister before turning the gun on himself in the family home. Finally, in Oregon, a Republican state senator who was a U.S. Army Special Forces veteran introduced extreme risk protective order legislation following his son's own suicide. His son was a U.S. Navy veteran himself. His father explained how his son never fully recovered from the trauma of war. Duke University studied Connecticut's extreme risk protective orders, and they found that the law prevented more than 75 suicides over a 14-year period. From Connecticut to California, from the bluest of blue states to the reddest of red, states all across America are adopting this approach to help stem the tide of gun violence. This approach has been endorsed by writers at the National Review and the Washington Post, and a myriad of publications from one end of the country to the other. It's time we adopted the extreme risk protection orders provided for in my bill, House Bill 2227, and started saving lives in Pennsylvania. Mr. Chairman, that is all I have in terms of testimony. I'm happy to answer any questions that the members may have.
Thank you, Representative Stephens. Are there any questions? Representative Miller?
Sorry, you all right? Todd, thanks for your thoughts and your passion on it. It's been pretty interesting. I've been trying to do some research along your proposal and some similars with it as well. Appreciate your emphasis on some of the work that Connecticut has done. I'm from Connecticut, so I appreciate it. Grew about 15 minutes from Sandy Hook. Did you, or have you been able to compare, I guess, 2 things. One is how the standard would relate to mental health commitments that currently we do? I'll wait. Go ahead.
Yeah, so that's a great question, and I certainly appreciate it. You know, with the current, particularly 302 procedure that exists in Pennsylvania law, there's a couple issues there. The first is, and this came from the Department of Human Services, the 2 key factors are a person must be severely mentally disabled and in need of immediate treatment. The severely mentally disabled is a pretty high threshold there. But on top of that, there's a tremendous reticence amongst family members to actually involuntarily commit a loved one to a mental institution. And, you know, there's a lot of folks who might not need to be involuntarily committed in order to protect themselves or others, but at the same time might need to be separated from their guns for a short period of time in order to ensure the safety of themselves or others. I read a study where it said most people who commit suicide think about it for some period of time, but don't actually decide to do it till about 10 minutes before they actually commit the act. And so there's a ton of data about the increased rate of suicide when there are firearms available to the individual. And so, you know, this would go a long way, as the data from Connecticut shows, to helping reduce those suicide rates. It would allow people to get help for a loved one without the stigma or really the heavy-duty impact of involuntarily committing them. The other thing is, when you're brought in for the involuntary commitment, a lot of folks, and I don't know if this is required by law, but nonetheless, a lot of folks are given the opportunity to voluntarily commit themselves. Well, that might be great for that night or for that short period of time, But, what happens beyond that? And so, and in that situation, none of the guns would be removed from the home if they are if they agree to be voluntarily committed. And can I just say one last thing on this front? The other thing that's interesting, the 302 commitment doesn't involve any of the due process. So flipping over to the gun rights perspective, there's no due process afforded to people who are 302'd. None. They don't get a lawyer. They don't get to present evidence. They don't get to cross-examine their accuser. They don't have any of those protections, and they lose their firearms rights for the rest of their life without the ability to have them restored, ever. And so, on the one hand, you have this stigma which, causes people to be reluctant to 302 their loved one, and on the other hand, you have an absence of any constitutional protections and a lifelong ban from possessing guns that cannot be undone. And, I just think that there are a number of problems with that, and so having this alternative would be helpful for us in Pennsylvania.
And I'm sure the good chairman wants me to be quick here with it. So a couple quick things with it. I appreciate you mentioning the due process situation with it. And I do think that some public defenders' offices may be covering perhaps other things that some do not. Would your proposal, just so I understand it, the right to counsel, I think you said if they could not afford one could be appointed. Did you actually have a suggestion of where that attorney would come from?
It would come from the public defender's office in my proposal. And I'll confess, that is unique. None of the 5 states, as far as I'm aware of, provide for the rights of counsel. But just to give you the genesis of that, what I didn't want to have happen was, Mrs. Smith is worried about her son, and now, her son, who's a gun owner, shows up in court, and Mrs. Smith has some, high-powered attorney who's there to represent her and help her through this process, but he is sitting at counsel, at the table by himself without representation, and vice versa. I didn't want, the gun owner to show up with an attorney, some high-powered lawyer, and Mrs. Smith to be without the assistance of counsel. So in this case, the district attorney is able to participate in the petitioner process, and the public defender would be able to participate, or they'd have their own counsel.
Todd, you're killing me with the time. So real quick, just a thank you.
I'm a lawyer, Dan. Yeah, I mean, I got to answer your question thoroughly.
So in Allegheny County, when you go apply for a public defender's office, there's a income threshold. In your proposal, does that income threshold still apply?
Yes, it would be whatever the income threshold is for a public defender. If you satisfy that, you'd be covered.
Thank you. My last question for you. In relation to your review of the other states, were you able to, was there data that showed how many of these proceedings actually occurred? And sort of like any idea as to how long they lasted or appeals, perhaps, that came out of it. Are we aware of those numbers?
I didn't see data on appeals. There's some information about Indiana, although the article was quick to say that not all the information was entered into the database that this reporter was checking, so I don't know how reliable that data is. Duke University did this study on Connecticut, and I think that would probably be the best place to go in terms of trying to ascertain, how many of these actions were brought. Now, they have a little bit of a different approach in Connecticut than what I'm proposing, but at least it could give you some sense of it from the Duke study of the Connecticut law.
Thank you for your time, and thank you, Mr. Chairman.
Representative Barbin for question.
Thank you, Mr. Chairman, and thank you, Representative Stephens. Is there any bill that's recently come out of the Senate Judiciary or the Senate Chamber that is similar to your bill?
No.
Okay, thank you.
Any other questions, members? Representative Joswiak.
Thank you, Mr. Chairman. Todd, I think you have a great bill here. I think in your testimony you said for an extreme risk protective order, and I'm thinking that's the same as a PFA, family members or law enforcement could petition the court. What about a psychologist or a psychiatrist if they're counseling somebody who is not really antisocial, but, not normal, let's say that? Can they do this as well? Because I know the HIPAA law, this is my thing here, but this, a lot of this gun control stuff it should be some mental control here. And I think that the HIPAA laws restrict these doctors from telling law enforcement or the courts things, and that's federal law. I know, I understand that.
Yeah, we didn't have them included in the bill, but I'm certainly open to a conversation with you and the organizations representing those physicians and psychologists as to whether they'd like to be included. There's also talk about, guidance counselors at school. That may be another group of folks that we might want to include, but I'm certainly happy to follow up with you on this conversation and reach out to those folks. I've actually already presented the bill to the psychiatrists, and they're reviewing it now, but we'll be certainly happy to consider including them as well if possible.
Okay, thank you, Mr. Chairman.
Any other questions of members? I don't see any. So, Todd, you have circulated the bill. How many co-sponsors do you have?
Mr. Chairman, I'm sorry, off the top of my head, I don't know.
Okay.
But it's House Bill 2227, and
Okay.
I can recirculate the co-sponsor memo to the members of the committee if you'd like.
Suggest you do that.
I will.
Okay. Thanks for your providing testimony and talking about your bill.